It is June 23rd of 2026, and this is the Court Gallery. Coming up, a social media streamer is accused of stalking a man who he claims is an illegal squatter. In the house, the streamer just signed a contract to live in. Judge McNally has to untangle the internet's most bizarre roommate dispute. Then, Judge Simmons deals with a defendant accused of secretly filming his victim while out on bond. And the situation gets even more complicated when the court learns his mother lives just 2 blocks away from the protected party. From bullet holes to bond violations, the defendants in this docket seem more happy to explain every detail of their questionable decisions. All that and more starts right now.
Okay, so Mr. Westfall, we're going to go on the record in the matter of the City of Wyandotte versus Nikia Harris, 26384.
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Ms. Harris. Ms. Harris, would you please state your full name for the record?
Nikia Harris.
All right, and good morning. Today is date scheduled for a bond violation.
Good morning.
As well as sentencing. The sentencing is for your client's plea to an amended charge of operating while visibly impaired by alcohol. The original charge of operating while intoxicated was dismissed by way of resolution between counsel at the pretrial. And there's also a bond violation hearing. Your client was ordered not to possess or consume any alcohol or drugs unless prescribed. That was as of March 24th at the arraignment pretrial. And it's alleged that your client admitted to drinking alcohol on May 8th. And counsel as to the bond violation.
Yes, Your Honor. And at this time, we are prepared to enter a guilty plea. Moving forward, Ms. Harris understands that she's not to consume or possess alcohol.
All right, ma'am, I'm going to have you please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Ma'am, are you sitting on? What are you sitting on?
At work, on the chair.
Okay. All right, ma'am, you heard the allegations, correct?
Yes, ma'am.
As to the allegation that you tested positive, that you consumed alcohol on May 8th of 2026, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, I did. Yes, Your Honor.
You understand that you have the right to have a contested hearing, and you'll be waiving some of those rights by entering into a guilty plea, correct?
Yes, Your Honor.
And you understand as well the possible penalty as a result of this plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Okay, and so, counsel, has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea, ma'am?
No, Your Honor.
All right, counsel, if you can please pardon your client.
Ms. Harris, were you on bond through the Wyandotte District Court on May 8th of this year?
May 8th?
Yes.
On bond. Oh.
And at a interview with probation, did you admit to consuming alcohol on May 8th?
Yes, I did. I was being honest. I had one drink on Secret of my Heart at the work for 13 hours.
Okay, and you understand that that was a violation of your bond order, correct?
I know, I ain't know, but I was telling the truth on my paper.
Right, but you understand that that was a violation of bond.
Yes. Yes, she told me that.
Right. Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violation. Ma'am, I can appreciate your being honest, right? That's what we need.
Yes, ma'am.
But so that this court can ascertain the appropriate sentence for you.
Yes, ma'am.
However, this court did order you not to possess or consume any alcohol or drugs unless prescribed.
Yes, Your Honor.
So, counsel, as to sentencing on the bond violation.
Yes, Your Honor. Ms. Harris has been open and honest. She's not trying to conceal or hide anything or deceive this court in any way. She's not going to put herself in this position again. So I would just ask for leniency on behalf of Ms. Harris.
All right, ma'am. So what gives? Why did you violate this court's bond order and consume alcohol?
It was sick of tomorrow. We was at work for 13 hours. I've been busy from time we open up to the time we close. And I said I'm gonna have one drink and that's it. And then just one drink at home.
Okay, ma'am.
I had a stressful day.
I can appreciate that. Go for a walk. Don't drink alcohol. You're in court because you consumed alcohol while you were driving or prior to driving. And then you had a 0.147. So this court, as a condition of bond, ordered no alcohol. No alcohol unless you had a stressful day at work.
I haven't drinking a month now, Your Honor. Almost 2
Very
months.
good. Tell me, I will indicate sentencing on that matter in just a short bit, counsel. Let's talk about the sentencing and the PSI. Did you have an opportunity to review the pre-sentence investigation and report with your client, counsel?
I did, Your Honor. And at this time, there's no additions, deletions, or corrections that need to be made. I would just like to note that Ms. Harris has no prior criminal history whatsoever. She is gainfully employed, as she indicated. She works very long days. She works about 7 days a week. They're short-staffed right now, so she's helping pick up the slack. I would just ask that the recommendation be adopted on behalf of Ms. Harris.
You gotta tell me about your medical marijuana card you obtained while on bond.
Yes, I did, Your Honor.
Yes, I know that. That's why I asked you to tell me about that. Is it from your treating physician or did you go into a marijuana clinic doctor to make that prescription?
Treating, and I'm trying to find me another doctor. It's hard to find me a doctor for the insurance I have.
Sorry, what's that?
I get from a doctor, but it's hard for me to find a doctor to fill the paperwork out for me.
Ma'am, I just need a letter from your treating physician that indicates that your doctor is recommending that course of treatment.
I had the paperwork in the car, but I have not found another doctor to fill the paperwork out. My doctor checked my heart and my blood pressure. I haven't found a doctor for that yet.
Okay, ma'am, you have a primary care physician, correct?
Yes. No.
Okay.
Kind of. Yes. It's hard. This insurance I have, it's hard to find a doctor. I gotta go far out.
Hold on. What I'm reading is that you have high blood pressure, kidney disease, arthritis in your knee, and you're under the care of a PCP, and you have medication for high blood pressure. So that tells me that you have you have a treating physician.
Yes.
Okay. So did that treating physician recommend the use of marijuana for your medical ailments?
No, not yet, ma'am.
Yeah. Okay. So until I get something from your treating physician, you can't use marijuana.
I have not.
Okay, good. Because this court needs to make sure there's a bona fide patient-doctor relationship and not just doctor shopping for the sake of getting a prescription for marijuana.
Yes, Your Honor.
All right. The court's going to find, after hearing from counsel, hearing from Ms. Harris, reviewing the report, the recommendation, the court does find there's reasonable grounds to Department of Sale 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Harris and the legislative guidelines. The court's going to order 12 months probation. You are eligible for early discharge, which I will go over shortly. You're not to violate any criminal law of any of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms, so you can help, you can have additional assistance in maintaining sobriety, preventing relapse, which will hopefully prevent this matter from happening again. You are to enroll in you're to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. The court's going to also order 5 days on the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and go back to the community. Do you have any questions regarding any of those conditions?
Yes, Your Honor. My son, he travel football. We go to state.
Okay. And how is that your 12-year-old son?
Yes, Your Honor.
Okay. And so he's on a travel football league in the summer?
Yeah, all year round.
Does he play for a school?
For the city, ma'am. City and school.
Okay.
We're supposed to be leaving town. We're supposed to be leaving town Friday to Atlanta, Georgia.
Well, ma'am, here's what I'm going to indicate.
Yes, ma'am.
Whenever one of those is coming up, you need to communicate with your probation officer, and then your probation officer will communicate with myself, or will, based upon how you're doing, grant that permission themselves.
Yes, Your Honor.
If there's a violation, you can be assured that you will not be traveling.
Okay. Yeah, he's supposed to be leaving Friday.
Okay, then you need to submit all those details over to probation, okay?
Okay. I could take a tour tomorrow when I get off work, or Friday.
Well, it's not advisable to give it to us the day that you want to leave. In the event that you're not able to leave, then your son will need some alternate transportation.
I mean, I can't leave the city. I can't leave the state at all. Go to a.
Not without permission from the court, ma'am.
Yes.
So, if your son, where is your son expected to go? Where's your son playing this weekend?
Indiana.
Okay. So that's out of the state. So then you would submit your request to probation. Do you have an email address, ma'am?
Yes, Your Honor.
Okay, that's probably the best way to do that.
Okay.
Okay?
Yes, Your Honor.
This week is a tight turnaround. Obviously, when's the next time that he's scheduled to be out of state?
In July.
July what?
I'm looking at my phone. Hold on, Your Honor.
Okay.
I know July 1st through the 5th. Yeah.
Okay, then you want to get those. Then you want to get those dates, ma'am. If there's other dates in July, I'm sorry. What was the other dates? I thought you were done. I'm sorry.
I'm sorry, July 1st through the 5th. Hold on, I'm looking at my group check, Your Honor. Ohio, we're going to Canton, Ohio, July 1st through the 6th. Then Atlanta, Georgia, sometime July something.
Okay. So, ma'am, hopefully that will be incentive for you to not violate any of the court's orders. If there's a violation, rest assured you're not going with your child. So, so I will make a note that. So please email those dates into probation with your request to leave the state with your son. And then again, as I said, ma'am, if there's a violation of any of the conditions, you will not have permission granted for you to travel. Okay, whether it's this time or any of the dates in July.
Yes, Your Honor.
Okay. All right. $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. Since you are eligible for early discharge, half of that can be paid. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. $200 for the workforce. That's 5 days, $40 a day, total of $1,625. And then as to your bond violation, this court's going to order Silverlink for 14 days through the Wayne County. So you're going to information about getting that as well.
Say that again, Your Honor.
As for your bond violation, I'm going to have you, there's going to be a device to blow into multiple times a day for 14 days. So you'll get that information also from probation.
Okay.
All right. As I did indicate, you're eligible for early discharge. As long as all the following have occurred. You continue to be staff of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you can give good faith effort to open full payment. Please email into probation by 10:15 and somebody will be with you shortly. Okay?
Okay.
Thank you. Have a good day.
Thank you, Judge.
Your Honor.
All right, let's go off the record. Let's go on the record. In the matter of Keena Jones versus Mackenzie Cole, 25th District Court case number 2522261. Ms. Jones, I'm going to have you come over to the table here, please.
Third ones.
I'm sorry?
Also the Kevin and
Yes, Billy Herborn. It's still the same case number. Yes, 2 defendants. Okay. All right. So today is the date scheduled in this matter for a trial of sorts. And there were subpoenas sent out and witnesses were scheduled to be here. The court received a communication.
I'm sorry to interrupt, but we have witnesses in them. Do you want them out first?
No, ma'am. I know how to conduct the court. The court received communication from Ms. Cole that her front door has bullet holes in it. And she will not be attending today. The court, through its staff, responded to her and had her send in pictures to support that, as well as a police report number as well. And because the police were currently at her home. And so for those reasons, Ms. Cole and Mr. Herborn are not present. So the court does find that would be good cause for an adjournment because they currently have police at their home based upon these bullets that are in their home. It appears to be 1, 2, 3 bullet holes.
I'm confused because they don't live together anymore.
Well, Ms. Cole was just on a whole conversation with my court staff and sent this information in. She did provide a new address for herself.
Okay.
So,
I'm sorry. I'm sorry that happened also.
so we're going to have to adjourn this because I can't, I do find that that's good cause for an adjournment.
Absolutely. I agree.
So, witnesses, I appreciate you logging in. I have to still get to that issue as well, but this is going to have to be set for a new date. Miss Cindy, are you Miss Cindy?
Yeah.
Okay. I appreciate you making the trip in. I was unaware of this information when I had you, come on in. Okay. So the witnesses that were asked to be here, you all may sign off. That's no problem. Miss Jones, I'd like to see the subpoenas copies of the subpoenas that you sent out.
Okay. One is with the Lincoln Park Court. Because that one you said to serve to the building department. And then these ones, I just asked them if they could attend and they said they would. That's these.
Well, I'd like to know why these witnesses thought that they should be on Zoom and not in person, ma'am.
I think that was a misunderstanding on my behalf because I asked the clerk because one is a doctor
And the request was denied. So why would,
She gave me the Zoom address and she said, yes, they can send Zoom.
who gave you the Zoom address?
The woman at the, off of the window. Don't.
Did you just simply ask for the Zoom ID?
I asked
Or-
the day.
Or, excuse me, just one moment. Did you simply ask for the Zoom ID? Or did you ask if they could appear via Zoom?
I asked her if they could appear via Zoom because one has patients, etc. And she said, yes, they can. Here's a Zoom ID.
Okay, no. What, no, I will tell you right now that there was a request made to me by Miss Nilsson, who's one of our clerks. And I denied the request for the doctor to appear via Zoom and said in person. So my question, ma'am,
I'm sorry, do you mind if I have back issues?
that's fine.
Thank you.
When was the Zoom ID added to these subpoenas?
When I came to pick them up from here,
Right. So you added them after I signed the document.
I'm not sure. Well, I assume it was because you must have signed them, but I asked the clerk.
Ma'am, I signed a document. You do not make changes to a document I signed already. Because I did not
Okay.
approve of a change being made to a document that has my signature on it.
Okay. The clerk also made changes, but I understand.
Well, I will have a conversation with that individual as well. When I sign a document, changes do not get made.
Okay.
You take that document as it is. This court did not grant permission for anybody to appear via Zoom. Which clerk did you speak with?
I think her name is Alyssa.
Alicia?
Alicia? Is she
Right, yes.
Yes, so I asked her if that would be okay, and I was told yes. I didn't have the Zoom.
She told you no. I can tell you that.
Well, I was provided the Zoom number. I didn't have it. I didn't know it. Either way,
just because you provided the Zoom number, ma'am, did not give you permission to add that onto a document that I had already signed. So we have to pick a new date. And also, ma'am, if you look at here, it says you are ordered to appear personally at the time and place stated below. Other 27 District Court with the address. So now what happened is you went ahead and on your own added the Zoom ID number onto these documents. So an attorney even somehow didn't read the document correctly because it says that someone's ordered to appear here. Nobody gave permission for Zoom appearances. So as I stated, the court finds good cause to adjourn. And we're going to have to pick another day. We can do July 21st or 28th. Do either one of those days work for you, ma'am?
yes.
All witnesses are to be in person. Which one works better for us?
36 days, the 21st is at 5.
Oh, that's the third Tuesday. Okay, so July 28th at 1:30.
Yes.
Does that work? Okay. Okay,
1:30.
yes. So ma'am, just so you know, you'll have to do all new subpoenas. Unless you want to contact them, letting them know. I will say that the subpoenas are to continue, but as it states, all are to be in person. So I don't know,
I can notify them, I just can't afford a subpoena anymore. I just not in my budget on my disability.
okay, so you just have to notify them to let them know that this is all, that you have to notify them of the new date. And then we'll give you back all these documents here. Thank you. Please make sure people are dressed appropriately and not in shorts, okay, ma'am? Any of your witnesses. Just let them know proper court attire, please. Okay. All right, let's go off the record here for a moment. And then Mr. Westmoreland, are you ready to proceed on?
Could you let my doctor, she can log out?
Oh, this is your doctor? Okay.
Yeah. Or
I'm sorry.
Miss Bohr, Dr. Bohr.
Okay, Dr. Bohr, you are all set to log off. There's a new date of July 28th at 1:00. Okay, thank you.
Emily Joy Crawford now appears at the Butler County Detention Center Zoom location. This matter was scheduled to come before the court yesterday for evidentiary preliminary hearing. Mr. Sweeney and the court appeared on time at the scheduled time of 10 o'clock. The defendant did not appear, nor did defense counsel. Defense counsel did give advance notice to the court of running late. The defendant did not. Following a 5-minute delay with no words regarding the defendant's status, this court ordered bond forfeiture, a bench warrant for failure to appear, and a no bond hold. Later that day, Mr. Favre, as part of handling another docket, addressed the court and asked for this hearing to be scheduled to address the status of Ms. Crawford's case after she was taken into custody. So, Mr. Favre, what request are you making to the court, and what is the status of this matter?
Yeah, thank you, Judge. So, procedure-wise, we are still at the point where Ms. Crawford is requesting a preliminary hearing to be set. I've informed Ms. Crawford of her options, and that is what she was requesting. The understanding I have from speaking to her and her spouse is that they had a battery car problem, some kind of a alternator issue that was causing their car to not run well, and that ended up with them being 10 minutes late to the courthouse. I understand from her husband that he called me at 2:00 yesterday. He said he'd been sitting outside the courthouse for almost 4 hours. He dropped her off at like 10:10, I guess. And at that point, she had already been placed in custody, and he only knew that she'd been placed in custody because he had a tracker on the phone that GPSed to the jail. So he figured out that she'd been taken with her phone to the jail. So, Judge, we're asking that the court consider reinstating her bond on this matter and that we set an evidentiary preliminary hearing schedule for her. That's our request at this time.
I don't know if you were available on the July 15 date that the court had been using recently, Mr. Favre.
Unfortunately, I'll be out that whole week, Judge. No.
All right. Well, the court believes the first item of business is to get this rescheduled on an appropriate day. I want to make sure I allow enough time for the state to reissue subpoenas. Friday, July 10, Mr. Favre, are you available then?
No, unfortunately, I will be out then. I'm taking a bit of a longer trip because we're going to Oregon and back, so it's kind of a long
All right.
drive.
So when will you return?
The 23rd. I'll be working the day of the 23rd. That day is pretty packed already. So probably the following week is when I realistically have some time.
Do you have availability on Monday, July 27, Mr. Favre?
I do at 4:00 that day.
Sweeney, can you make that work?
I can, I can, Your Honor.
All right. The Crawford evidentiary preliminary hearing will be rescheduled for Monday, July 27, 4:00 p.m. All right, Mr. Sweeney, Mr. Favre has made a request regarding reinstatement of Ms. Crawford's bond. What is your position on this?
Your Honor, the state generally objects to modification of bond when there's a failure to appearance at an evidentiary status, and I think generally in this case as well, we would make that same request and same objection.
Ms. Crawford, a couple of things strike this court
Judge,
as odd. Just a minute, Mr. Favre. Ms. Crawford, first of all, if you're running late, you didn't contact anyone at the court or your attorney or anyone else. That strikes the court as somewhat unusual. The other thing is your husband sat out in the car for 4 hours without checking on you. That also seems a bit odd. He could have just came in and probably determined your status at the security desk, but that's his time involved, not the court's. Mr. Favre, you had some additional remark you wanted to make?
I did, Judge. I also failed to mention two things. The first is I think that Ms. Crawford hasn't had any failures to appear thus far in this case. She is H-box criminal history, so she will be presumptive probation. In addition, speaking to her husband, apparently she's fairly integral working on their family farm. She's doing a lot of physical labor, so I think that her loss would really be a hindrance to their family's productivity this summer. So we'd like the court to take that into consideration when weighing our request as well.
Well, I haven't received any requests from the surety to be released from her bond. She is under a $2,500 AAA Butler County bail bond. Where do you live, Ms. Crawford?
I live in Rock.
Okay. Do they not have addresses in Rock?
436 Winfield Street.
So was that actually in that little town there?
Yeah, it's actually in that little town.
But you're on a farm?
My own place has dogs, but out a mile from my house is the family farm. They're on 42nd Street or 42nd Road. 10445 42nd Road is where his mom's actually at, and that's where all the farm animals are. But she's disabled, so she can't really do much of the farm chores, in a sense.
Okay. Well, perhaps if you answer a couple of questions properly, Ms. Crawford, the court will reconsider its position. What time is your court date, your next court date that we set today?
4:00 on the 27th.
Of what month?
July.
Okay. And where would you need to be?
At the courthouse in El Dorado, Kansas. They're on, I don't know what street that actually is. I can find.
As long as you can find it, the street isn't
Yeah.
important. It's the judicial center, though. You do understand that, right?
Yes.
Okay. And what time would you need to arrive?
10 minutes or more before 4:00. Preferably.
Correct answers, Ms. Crawford. I think because of your attorney's advocacy on your behalf, I still think that you're a risk not to appear. If you do it once, you don't take court seriously. You say you had a car problem, but you never called, never let anybody know your status. This court needs to get started on time. You understand that, Ms.
Yes,
Crawford?
I understand that.
And you need to be in place at the Zoom location at the Judicial Center on time.
Yes.
And because the state had, I think he had a witness ready to go. All right. The court will reinstate the defendant's bond, surety bond, with AAA Butler County bail bonds in the amount of $2,500 under the express condition that Ms. Crawford appear on a timely basis for all future court appearances, which was already a condition of her bond, which she didn't seem to understand. But she does need to appear at the Butler County Judicial Center for court at 3:45 or so on Monday, July 27th, so that we can promptly start our evidentiary preliminary hearing at 4. Okay. Am I tiring you, Ms. Crawford?
No, you're not. I promise. I'm sorry.
Okay, well, you just gave me a big yawn like you were bored or something.
No, sorry.
Ms. Crawford, do you have other holds on you?
No,
Just this.
just this.
All right. Well, I think the jail now has the information that I've reinstated your bond, so you can be processed out and released. You can call somebody and get a ride home, but just do not forget Monday, July 27th. We're going to start court promptly at 4 o'clock, and you need to be at the Judicial Center in El Dorado.
Okay. Yes, understand.
Okay. Mr. Favre, anything else we need to address at this time?
Not this time, Your Honor. Thanks.
Mr. Sweeney, anything from your perspective that we need to address?
No, Your Honor. Thank you.
Then the Emily Joy Crawford matter will be in recess at this time, and this meeting may be ended for all. State of Kansas versus James Dale Gage. It's case number 2023 CR 171. Brett Sweeney appears for the state of Kansas. Jorge De Hoyos appears as defense counsel. The defendant, James Dale Gage, appears from the Butler County Detention Center's Zoom location. This matter comes before the court at this time for sentencing. Court's docket notes indicate that Mr. Gage appeared before this court on April the 20th of 2026. At that time, pled guilty to an amended count 1, possession of methamphetamine with the intent to distribute, a level 4 drug felony. Count 2 was dismissed pursuant to plea agreement. A pre-sentence report was ordered and sentencing set for today. Court has received a completed pre-sentence investigation report compiled by Kelsey Moore, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history that's stated in this report?
No objection to the criminal history, Your Honor. Thank you.
Is there any objection by the defense to criminal history, Mr. De Hoyos?
No, Your Honor, there is not.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Mr. Sweeney, are you aware of any legal reason why sentence should not be pronounced in this case here this morning?
No, Your Honor.
Mr. De Hoyos, are you aware of any such legal reason?
No, I'm not, Your Honor.
Mr. Gage, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing this morning?
No, Your Honor.
Court will proceed further then. Does the state have any motion for a departure sentence pending at this time, Mr. Sweeney?
We do not, Your Honor.
Does the defense have any sentencing-related motion, such as a departure motion, to pursue at this time, Mr. De Hoyos?
Judge, as I understand it, Mr. Paul did file a motion to apply border box findings in this matter.
Okay. Did you wish to provide argument in support of that motion at this time, Mr. De Hoyos?
Judge, you may have heard Brett and I communicating. The court in the companion case of this matter in front of Judge Hart did order a border box finding in the matter because Mr. Gage is making tremendous strides in his sobriety. And Ms. Nelson is here from the Substance Abuse Center of Kansas to speak more on that. That being said, Judge, you look at his criminal history, drugs and alcohol have been his problem for years, for decades. And we need to fix that. He's actually shown some strides that make it believable he might recover. And I'm hopeful you give him the opportunity to do just that.
All right. Did you wish to call Ms. Nelson as a witness?
Judge, I'm not going to interrogate her, but by all means, I'd love her if you'd like to hear from her, sir, that she might have a moment to speak with you.
Any objection to that procedure, Mr. Sweeney?
No, Your Honor.
All right. Ms. Nelson, did you wish to address the court?
Yes, Your Honor. So I kind of prepared a character witness statement as far as what Mr. Gage has done over the past 24 weeks now. I'm Ashley Nelson, a peer mentor with Substance Abuse Center of Kansas. I facilitate the drug and alcohol groups within the Butler County Jail. Over the past year, I have worked with well over 100 inmates. In that time, I have seen a wide range of engagement. Some individuals attempt to simply pass time. Others participate more sincerely. However, the level of commitment and personal growth that Mr. Gage has demonstrated is truly exceptional. Mr. Gage entered the program already carrying 18 months of sobriety, a clear desire to better himself. What sets him apart is not his starting point, but the effort that he has put forth since. He has not only completed all required work, but has accelerated through the program, completing levels 1 through 3 in approximately 14 weeks, which usually takes about 21 weeks. This speaks volumes about his discipline, focus, and genuine commitment to his recovery. Beyond completing the program, Mr. Gage has actively sought out other available resources to support his continued success upon release. He has taken the initiative in developing a detailed release plan, including continuing outpatient treatment and pursuing sober living to maintain structure and accountability. His intention is not to remain sober, but to deepen his understanding of recovery and build a stable and meaningful life while in recovery. One of the most telling aspects of his growth is reflected in a letter that I ask all participants to write. It's a hypothetical reflection on how their death would impact the loved ones if they continued in addiction. Mr. Gage approached this assignment with profound honesty, compassion, and accountability. While many participants write from a place of ongoing addiction, Mr. Gage wrote from a lived experience. He understands loss, grief, and the weight of regret. The loss of his mother, particularly under the circumstances he carries, has clearly impacted him deeply. He has hit rock bottom with the loss of his mother while still in addiction. Rather than allowing that pain to pull him backwards, he has used it as motivation to move forward with purpose. In addition, he has shown strong dedication to rebuilding his faith. He has completed both books of Celebrate Recovery, which is a Bible-based principle with the 12 steps of recovery. This is a significant accomplishment. Very few participants complete both workbooks, and it reflects both his spiritual commitment and willingness to do deep internal work. He has also completed many classes on the Adobo app that's part of the tablets curriculum at the Butler County Jail, including 38 classes, topics like thinking about the future, cognitive behavioral therapy, forgiveness challenge, anger management, prison reentry network, and many more. He has also expressed a sincere desire to give back. Mr. Gage has shared his interest in becoming involved in the recovery community, including participating in local coalitions focused on supporting individuals struggling with addiction. He wants to use his story to help others, which is often one of the strongest indicators of lasting recovery. I understand that many individuals stand before you with promise of change. What I can say with confidence is that Mr. Gage's actions align with his words. He has already begun doing the work. He has done the work with consistency, humility, and purpose. I truly believe that if he was given the opportunity, Mr. Gage would continue on this path and prove to himself and you to be a productive, accountable member of society. More than that, I believe that he has the potential to become a positive influence and a mentor to others that are still struggling. That's all I have.
Very well. DeHoyos, anything else regarding the presentation in regards to the motion for border box findings? Jorge, I didn't hear your response because you're muted.
Forgive me, Judge. No, Judge, not in this matter.
All right, very well. Are there any victims and members of a victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present. So at this time, the court will ask for formal recommendations from counsel regarding an appropriate sentence for Mr. Gage, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, the state is recommending the mid-box here, which is 30 months in the Department of Corrections. Mr. Gage would be eligible for the 20% good time, as well as have a 24-month post-release supervision duration. He does have 143 days of jail time credit. Your Honor, we're asking that this 30 months that's being recommended run consecutive to the time in Butler County 22 CR 273 that he was just sentenced on June the 11th. I think he was on felony bond for this case when he picked up this case when he was on felony bond in that case. So we're asking that it run consecutive to that case, as well as all the Arkansas cases that are listed on the second page of the PSI, and those would invoke special rule number 9. Can
I stop you there?
Yeah.
What is the status of these parole cases out of Arkansas?
And that's a good question, Judge. I'm not sure what the status on the parole cases out of Arkansas is. I know, obviously, that the Butler County case, he's still got, the full 30 months outstanding and hanging over his head. But he would probably be in the best position to answer that. Maybe court services might have some insight on that as well. But I'm not sure how much, if anything, is still outstanding on those.
You may complete your recommendations, Mr. Sweeney.
Thank you, Your Honor. So as I've kind of alluded to, Judge Hart did place him on probation and make border box findings in that 22 CR case. Obviously, this is a separate case, and an independent valuation will be made. But the state is not opposing border box findings being made. I don't know what the court's ruling will be to that effect, but I have taken a look at the proposed recommendations of probation if that's adopted, and they all appear to be appropriate. As far as the costs and fees associated with the case, Your Honor, the state is not requesting a fine. We are requesting the court costs in the matter. There was a KBI laboratory report. We're seeking $400 there. Would ask the court to impose attorneys and bids fees if those are appropriate. And then additionally, Your Honor, the 22 CR case is a marijuana case, so distribution case. So he's not made to register on that one, but this one is a meth distribution case. So he's going to need to register as a drug offender for 15 years on this case. And that's all I have in the way of recommendations, Your Honor. Thank you.
Very well. Thank you, Mr. Sweeney. Mr. DeHoyos, your formal recommendations?
Judge, we're asking that you grant the border box motion and encourage the defendant to continue his sobriety and continue his great work with the Substance Abuse Center of Kansas. For all the reasons Aaron stated in my motion and by Ms. Nelson, and for the reasons that my client will share with you, I'd ask that you consider him for the border box findings and allow him to continue his great work in sobriety.
Very well. Thank you. This time, the court will address the defendant, James Dale Gage, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
Yes, Your Honor. I wrote a letter to the court, if you wouldn't mind if I read it.
You may.
Thank you, sir. Your Honor, I come before you with a humble heart, taking full responsibility for my actions and the choices that led me here. I am not here to make excuses or place blame. I am here to be honest, to be accountable, and to ask for an opportunity to continue proving that I have truly changed. Addiction is something I have struggled with, but today I no longer hide from that truth. Instead, I face it head on every single day. Recovery has not been easy. It has required me to break myself down, to be honest about my past, and to rebuild my life with intention, faith, and discipline. I have put my whole heart into this journey. While incarcerated, I have taken every opportunity to grow. I have been actively involved in 12-step meetings and classes through the Substance Abuse Center of Kansas here at Butler County Jail. I have also completed both Celebrate Recovery books, 1 and 2, like Ms. Ashley said. Each of these books walks you through the steps of Alcoholics Anonymous alongside the Bible. And I can honestly say that without them, I would not have found the deep meaning I now have behind both my recovery and my faith. They didn't just teach me how to stay sober. They helped me understand why I was broken, how to heal, and how to turn my pain into purpose. Through this process, I have built a relationship with God that I've never had before. I read my Bible every morning. I pray before every meal and every night, and I lean on my faith in ways that I've never thought possible. I truly believe that without Him, I would be where I am. I would not be where I am today. I have surrendered my old life and committed myself to a new one. The loss of my mother in September 21st, 2024 changed me in a way I cannot fully put into words. She was everything to me. I carry deep regret that I did not make these changes while she was still here to see them. That is something I will always live with. But her passing became my turning point, my rock bottom. As painful as it is to say, losing her is what finally opened my eyes today. I lived my life trying to make her proud. I hold on to the belief that she is in heaven watching over me, and that gives me strength to keep going. I have been clean since September 24th or 23rd of 2024. This coming September will mark 2 years of sobriety. While I understand that part of that time I've been during my incarceration, I was clean for a full year before I was locked up. That matters to me because it proves to myself that I can live the life on the outside as well, and I am determined to continue that journey. And I'm working with my peer mentor, Miss Ashley, in Substance Abuse Center, and my goal is to give back. I don't just want to stay sober, I want to help others who are where I once was. I want my story to mean something. I want to be someone who can reach back and help the next person up. When I am released, I plan to continue my treatment through the Substance Abuse Center of Kansas with outpatient services. I also attend meetings regularly and find a sponsor. I am willing to comply with any conditions the court sets, including regular drug testing, because I want to prove that the change is real and lasting. I have learned the hard way that life living was not worth what it costed me. I have lost too much, but I have also learned something that changed me forever. Giving up one thing, my addiction, for everything, my life and my future and my faith, is worth it. Your Honor, I am not the same person who stood before you before. I am doing the work. I am changing from the inside out. All I ask is for that chance to continue that work outside these walls and to prove through my actions that I can be a commitment to different life. Thank you for your time and consideration.
Very well, Mr. Gage. We'll pronounce sentence at this time. Court establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine with the intent to distribute, a severity level 4 drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 4, drug E. The court hereby sentences the defendant to a term of 28 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 24 months of post-release supervision. The court imposes no fine in this case. This court notes that in grid box 4, drug E, this is essentially a presumptive prison case. It is subject to a non-departure community-based sanction and an alternative should the court make certain findings to support it, which has been asked for here. The court further finds that the crime in this case was committed while on felony bond. This troubles the court, Mr. Gage, because you had a new possession of methamphetamine case pending in this court. You were given the privilege of bond, and you went out and possessed methamphetamine all over again in sufficient quantity that it was a possession with the intent to distribute, or under circumstances of possession with intent to distribute, which just kind of tells this court, Mr. Gage, that no matter what the court system does to give you a break or to give you a release to the community, you're going to continue to do this. Now, today it's advocated that after all of the drug cases you've had, all of the theft cases you've had, and all the times that you've been in court, and all the times that you've had an opportunity to get yourself straightened out and off drugs, only now in 2026 are you ready to be a productive member of society and stay off drugs. Why should this court believe you now when you've never done it before? You've had a long period of incarceration. That's what separated you from drugs and drug culture. You have participated in some programming while you've been in the jail, and I give you credit for that. And that certainly has contributed to this court imposing a mitigated sentence in this case. But the ultimate question before the court is, because this court finds that this was committed while you were on parole out of another state, you committed these crimes while you were on felony bond out of our very court system, and because this is a presumptive prison case to begin with, subject again to some border box findings, should this court grant you yet another break? And Mr. Gage, the court ultimately determines that it will not. This court will invoke the special rule in this case This crime was committed while on felony bond in Butler County case number 2022 CR 273. The crime in this case was committed also while the defendant was on parole out of the state of Arkansas on multiple cases whose status is not yet clear. And this is essentially a presumptive prison case, and the court declines to make border box findings in this case. This court will order the presumptive prison sentence of 28 months in Department of Corrections custody, which of course will have that 24-month post-release supervision attached to it. And the court does run this consecutively to any of the Arkansas cases, which are still live and pending. Further, the court runs this consecutively to Butler County case number 2022 CR 273. The court will impose in this case a felony docket fee and $400 to the KBI laboratory. The court will waive all bids assessments in the case, even though defense services have obviously been valuable to the defendant. The court finds that due to the court's incarceration order, it would not be appropriate to impose any additional bids-related fees in the case. So those are waived in their entirety. Court does grant this defendant 143 days of jail time credit in this case. There's not an order of restitution other than the KBI laboratory amount, which the court's already assessed. I'll advise the defendant of his continuing obligation to register as a drug offender for a period of 15 years. That applies essentially during periods of non-incarceration. At some point in the future, Mr. Gage, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer, and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas may have the right to appeal their conviction to an appellate court having jurisdiction. And if the defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal, and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Mr. Gage, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Gage, I don't know what you face in the future, how much prison time overall you're going to be facing, but I encourage you to take advantage of any programming within any prison system that you might be incarcerated in to try to continue on the path which you claim to be long-term sobriety. I hope that you can eventually achieve that goal, not just when you're locked up, but when you get out and deal with stresses in other ways besides using very dangerous and illegal street drugs. Good luck in that regard, Mr. Gage. Despite the court's ruling here today, I'm pulling for you to eventually, when you get out, still be that drug-free individual that you claim to be striving for at this time. And I hope you make it. All right. The court will remand the custody of Mr. Gage to the representatives of the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 28-month prison sentence imposed here today. Mr. Sweeney, are you aware of other sentencing-related matters which the court needs to address at this time?
No, Your Honor.
Mr. De Hoyos, are you aware of any sentencing-related matter which the court still needs to address?
None that the court needs to address. I would just ask for a breakout room afterwards so I can speak to Mr. Gage.
The court will accommodate that. So, Mr. Gage, if you'll stay on the meeting after we recess, I think your attorney wants to continue to confer with you privately, okay?
Yeah.
All right, very well. There's nothing further at this time then. The James Dale Gage matter will currently be in recess at this time, and the court will conclude the record of these proceedings.
All right, I'm going to call them all. I have people against Lucas Charles Poindexter. When I call your name, you can come up to the podium. This is file number 26W841852. I have Colton Lewis Smith, 26W842735. I have Giovanni Joseph Wilczewski, 26W841855. And I have Jiden Armani Adams, 26W842737A and B. All right. Why don't you get these guys on one side here or the other? Are you Mr. Poindexter? Yes?
Yes, sir.
Wait a minute. Let's slow down. Can you turn that podium to me? Thank you. Mr. Poindexter, your name. What's your name, sir?
Colton Smith.
What's your name?
My name is Chesky.
Your appearance?
Good morning, Mr. Shanky, on behalf of these three clients, Your Honor. We did have an opportunity to speak with them.
Wait 1 second. I want to get Mr. Perlman's appearance, please.
Good morning, Judge Jeff Perlman on behalf of Mr. Adams.
Mr. Adams,
Yes, sir.
your name.
Don Adams.
All right. So you have 2 files. Okay, so let's just take these 3 gentlemen first of all. What are they going to do?
Judge, first off, a housekeeping issue.
And Detective Cern, I need your name. My apology.
Yes, Your Honor. Detective Cerno with the Woodhaven Police Department.
Yeah, I know conflict representing these three individuals at the arraignment. I did check with them. They have no issue with me handling their arrangements. That being said, I asked all 3 to waive formally my client was staying here.
All right, so I'm entering not guilty pleas for each one of you. And it says McDonald's employees did not want on property. Was told to leave, was there to harass the subject, took camera and went in to harass Joseph Lucrecio. Were they all in there doing that allegedly, Detective?
Yes, Your Honor.
So this was at a McDonald's?
Yes, Your Honor.
So I'm entering not guilty pleas, indicating that every one of them stand mute. I have not gotten yet to Mr. Adams. All right. I'm gonna need you to fill out 4 different bond sheets for me. Will you please? Here you go. I got it. Okay. All right, just put the names on there. So, gentlemen, you have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. You have the right to be represented by a lawyer at all subsequent court proceedings. If you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that, Mr. Poindexter?
Yes, sir.
Mr. Smith?
Yes, sir.
How about you, Mr. Wilczewski?
Sir.
All right, Mr. Perlman, for purposes of arraignment, how does your client wish to proceed?
For purposes of arraignment, Judge, my client would enter a not guilty plea, stand mute, and waive formal reading of the information.
I will enter not guilty pleas for him, indicate that he stands mute on both the disturb the peace as well as the stalking charge. What can you add about that, Detective Thurna? We're
Yes,
only charging him under a local ordinance though, right?
Yes, Your Honor. Yes, regarding the stalking charge, he made numerous unwanted contacts with Joseph Lucrecio throughout the day, and officers responded to multiple calls regarding this throughout the day.
Where does your client live at, Mr. Perlman?
Judge, my client lives in Texas. He has no criminal record. He had a right to be where he was, where this other gentleman was as well. But you know, he's not a flight risk. This is not obviously an assaultive offense. And you know, in terms of the you know, the nature of the allegations, I mean, my client maintains his innocence, but we would ask for a personal bond.
What are you asking for?
Yeah, all 3 of my clients recently graduated from high school, 2026. At least one of them is gainfully employed. The other 2 were dishwashers, but they're not employed anymore. However, Judge, they all have a strong family support system. They're not on probation rule. They have no priors. I would ask for a personal bond.
Detective Cernan, what are you asking for?
Yeah, and I'd like to, I'm asking the court to give some type of cash bond. Yesterday I said, the officers on the road had about approximately 3, calls come in regarding these, gentlemen here, causing some type of disturbance. So therefore I'm asking for a cash bond.
Where do you guys, so Mr. Poindexter, you live in Rockwood?
Yes, sir.
Where do you live, Mr. Smith?
Russell.
How about you, sir?
I live right.
You know how these guys hooked up with Mr. Adams here? I'm asking you, detective, do you know? He's from Texas and they're from.
I believe, Mr. Adams is a social media online streamer. I believe these, 3 gentlemen here saw his stream and wanted to meet up where he was, streaming at regarding him following around this Joseph Crucio, throughout the city of Woodhaven.
What kind of contacts did he have that would justify a stalking charge? Mr. Adams, I'm talking about.
Yeah, he was, Joe was at the McDonald's in the morning. Then they followed him back to his house shortly after. I know the officers transported Joe to the police station to get away from this, Adams and his group of people. And they walked into our station lobby, asking for him. And then the officers took him back to McDonald's, and the group here followed him back there again.
Your Honor, if I may,
Sure.
my client has actually a contract from the owner of the residence allowing to be at that residence. The complainant, he was squatting at that residence. My client was lawfully in that residence. Furthermore, he was at a McDonald's, and when he was asked to leave the property, he left the property. That's it. There was no stalking. The first time this person ever encountered my client was yesterday. My client had permission to be there from the owner, as opposed to the complainant who did not have permission to be there.
Well,
So
they've just charged under local ordinance, just so as you know, that's just a 90 or 93-day misdemeanor. It's not the 1 year, but I'm not necessarily disagreeing. I don't know enough about the case. How much does your client make, Mr. Perlman, in it, whatever he does for a living?
Your Honor, I don't have that specific number at this time. I would just indicate that he is a public YouTube presence, which requires him to maintain his reputation and again resolve this legal matter. He's not a flight risk. His public identity is built on accountability and transparency. He live streams his activities and operates openly with law enforcement agencies across the country. In fact, the incident is available on YouTube right now. There's complete transparency. Again, it's not an assaultive offense. First time my client ever encountered this person was yesterday. He has the means to travel and the means to return, and the court can be assured, and he's retained counsel, and the court can be assured of his appearance through the standard conditions. And we're asking for a personal bond and that he be able to travel as required for his work. He's not a danger to the community. He's in fact assisted in the arrest and prosecution of dozens of people across multiple states in cooperation with law enforcement. So we're respectfully asking for a personal bond, Judge.
Mr. Poindexter, Mr. Wilczewski, and Mr. Smith, I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to enter or go near 22172 West Road in the city of Woodhaven. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to have any contact no contact whatsoever with Joseph Lucrecio. You understand that? You cannot write, phone, see, text, email him. You cannot have anybody else do any of those things for you on your behalf. Do you understand that, Mr. Poindexter? Sir. Do you understand that, Mr. Smith? And you understand that, Mr. Wojcicki? Sir. I'm gonna set the bond on the stalking case. I'll give you a $10,000 personal bond. You can leave the state without the consent of the court. Mr. Adams, you cannot violate a law. You must appear in court as directed. I'm telling you, no contact at all with this Joseph Lucrecio. You cannot write, phone, see, text, email him. You cannot go back to 22172 West Road in Woodhaven. No contact with prosecution witnesses. Again, no contact with Mr. Lucrecio. You cannot have any contact with prosecution witnesses except through your lawyer. Has he been printed on this yet? Detective Cerna?
I'm sorry, was that Your Honor?
Has he been printed and photographed on this charge?
Yes, Your Honor.
All right, so you've already been printed and photographed, so I'm not going to order you to do that. But no contact with Joseph Lucrecio, no contact with prosecution witnesses. You cannot enter 22172 West Road, Woodhaven. I will let you Zoom for pretrials. The rest of you gentlemen. Hang on one second. Yes. The rest of you gentlemen, you're going to have to appear here, okay? Unless you retain a lawyer. Go ahead. What's your question?
When we have the legal contract to be at the house,
I don't want to talk about that. If you want to talk to your lawyer, that's a legal question. You can ask him.
Okay.
Okay.
So,
Judge, may I address? And I apologize. May I address? There also the law enforcement has seized my client's camera equipment, which is about $120,000 worth of equipment. There's absolutely no need for them to have that. Everything that occurred yesterday pertinent to this investigation is available online. I'm sure they have access to it. I'm sure they've saved it, but there's absolutely no reason for them to keep the camera equipment, which is, again, my client's livelihood and valued at approximately $120,000.
Here's what I think the appropriate remedy is at this point. I'll give you the earliest possible court date that you want. You can talk to the Woodhaven city attorney and explain your position. And if he disagrees, you can file a motion and I will hear it on the first court date. Okay. I don't know why they would be preserving that unless if there's some that has some evidentiary value. I'll say that, but I'm not going to willy-nilly go ahead off the cuff and order anything, any return of anything right now. I'll give you a pretrial date. When do you want to, what day do you want to have this pretrial? I can give you earlier than July 26th.
There is an afternoon docket on July 13th.
What did I have with Brownstown? I mean, with Woodhaven? Yes. So let's do it July 13th at 1 p.m. for everybody, okay? July 13th at 1 p.m. And again, I would encourage you to call Mr. Urich. If he doesn't agree to the return, then you can file a motion and I'll hear it on July 13th, okay?
Okay, thank you, Judge.
So, anybody have any questions? Mr. Poindexter, Mr. Smith, Mr. Wilczewski, anything else, Mr. Shen?
No, Your Honor.
Anything else from you, Mr. Perlman?
No, Judge.
And you heard what I just told your lawyer, right, sir?
Like asking the questions about.
Well, you heard what I just said about the camera equipment.
Oh, yes.
Okay. So we'll let it go with that. And I'll give you guys an early court date of July 13th at 1. And if somebody wants to file a motion because the prosecutor doesn't agree to it, I'd be glad to entertain it at that time. Okay.
Yes, I believe my client has a question. I have no problem with him asking.
What's your question?
Like I was saying, I am residing at the address you gave. Is that the address of the McDonald's or?
Yes.
Okay.
22172.
So I live in the house, not that McDonald's, but I live in the house.
What house?
Joseph is illegally residing in, squatting inside of. I did sign a contract with the homeowner to live there. And that
Where's that at?
That is, it's like about 3 minutes from the McDonald's. Like I moved in, all my equipment's there.
Wait a minute, slow down.
Yes, sir.
You tell me you're living in the same house as Mr. Lucrecio?
Well, he doesn't live there legally. He's
I don't care. Is
yes,
he living there?
Yes, he is living there.
You cannot have any contact with him. So you're gonna have to find another place. If you're gonna run into him by going back to that property address, you're not gonna have any contact with him, sir. You're gonna have to go elsewhere. Do you understand that?
Okay. Court provide anything or?
Well,
What do you
Judge,
mean?
I guess the concern and what the issue is that my clients are, bringing to the court is that my client has a legal right to be there, and this person does not have a legal right to be there.
What? How do you want me to decide that now? Now, wait a second.
There's a court order.
Hang on. You're telling me that. How am I supposed to determine that now, Mr. Perlman? Because you tell me and your client tells me that he's just squatting and he's illegally there. I don't have any authority. I mean,
I
come on,
understand- I
gotta get
understand that,
prosecutors
Judge.
involved and witnesses involved and police involved. And do you know anything about that, Detective Cerna? Is this gentleman a squatter, Mr. Lucrecio?
From my understanding, Your Honor, he is being evicted on this Friday. I haven't seen any eviction paperwork or anything. That's just what I was told from the officers.
Pending. Is it before this court pending?
I'm sorry, Your Honor.
It's got to be in this court, right? In this 33rd District Court, that landlord-tenant action?
Yes.
Well, I mean, guys, I'm just telling you, as of now, Mr. Adams is not going to have any contact with Mr. Lucrecio. Now, if Mr. Lucrecio is evicted before the next court date, I'll be glad to change my mind. But but I'm not going to sit here and make findings that the guy's a squatter or anything. I don't know anything about that. Maybe it was in front of me, maybe it wasn't. I don't know. I handle cases every day, but I'm telling you, you're not going back there if he's there. Do we understand one another?
If he's there, yes, sir.
Sir, don't go back to that house.
Okay.
If you go back to that house and he ends up there, you are not going to like what I'm going to do. I promise you that.
No, sir.
You're going to be sitting in jail a long time awaiting bond or awaiting trial.
Yes, sir.
Okay? I'm going out of my way. You're out of state. I gave you a personal bond on a stalking charge. Don't tempt fate. Okay? Good luck.
Thank you, Judge.
Thanks.
Thank you, Your Honor.
All right.
So, what we have here
We can go in the back and get away from them.
is live from JDion's live stream. Right now, as we speak, he is streaming inside the squatter's house until he leaves. Text to speech is on. Join in. It's a 24/7 stream, apparently.
Yeah.
Is that showing correctly?
Bro, stop. Stop, bro. They're going to arrest you. Please stop.
Here. I'm staying inside.
You just saw the court case, right? We literally just watched the court case.
That's the only light is the bathroom light. No, that's fine. We got this light. Skeeter!
So don't go back to that
Go
house.
upstairs.
Don't go back to that house, he said. What's happening right now?
Huh? Yeah.
What's happening right now? He went right
we
back
got
to
this
that
light.
house. It's tonight. This is happening tonight, right now. This is live. What we are watching is
Bro.
literally live.
I'm not gonna lie. If you're doing all that outside, you're actually so lame.
Yeah, the kids are saying some crazy things out there. So how did it even evolve? What were they saying?
This is you can't get any more telling on yourself, right? I mean, this is literally like, hey, I'm gonna not do what the judge told me to do, and I'm gonna live stream it.
Let me know if the cops come.
I'm gonna live stream it.
I actually want to show them.
See what Darth Malicious has to say here. Yeah, Yeah, they're gonna arrest you. Yes, Felix, that is him. That is the guy. Jadion is the guy who we were just watching.
Shot inside.
I want to make sure that's not too screwed. This is the guy who was in Judge Dad's court that we were just watching. He is at the house that wait, let me back up. He is at the house that Judge Dad told him not to go to. Now, whether or not the other party that he's supposed to be staying away from is there, can't tell you. Have no clue. All I know,
We'll just get another shot like that at the end.
all I know is
Do that after
they were in a
everyone.
car. They were driving. Now they're here, and they've been talking about this is the house. This is the actual house. This is in Woodhaven,
Oh, yeah.
Michigan.
They should come. That's actually horrible.
And they're dumping plastic
I don't think they've
balls
seen
through a porthole.
No, like I'll say, like because
In
you put the
a
camera in there, they couldn't see.
door.
Oh, they saw it. Yeah. Okay. It was like very minimal. It's like it went. Here, I'm gonna get a shot.
This is Eileen is saying it all right here. This is the point. This is the reason I stopped everything we were doing and came here to watch this. I could not believe it when I saw it happening live. Thank you so much for telling me the name of the live streamers channel. Thank you. Thank you so much for that.
What'd you do yesterday? I threw a ball at Gideon's head.
I want to get a few more of your comments in here. Let you see what's going on. We literally, just so in case anybody's just now tuning in, we just now watched a court hearing with Judge Dad, and this guy right here. And Judge Dad just finished telling him, "Don't you go back to that house. If you go back to that house, you're not going to like what I do, sir.
Bro,
Do you understand me?" These were the last words we heard coming from Judge Dad. Guess what house he's at? Guess what house this idiot is in? Guess where he is?
Bro, shut up. We don't need to return it.
That was him.
Bro, shut up. You shut up.
Why are they blowing the air?
Lee.
I'm not coming outside.
This guy's got thousands of followers, y'all.
Bro, there's no way we can
I mean,
put all them back.
he may have a point. Like what he's doing. You got a squatter squatting in the house. He's rented the house. Technically, he could be all in the right.
I've just fully accepted that.
And yeah, he's dual streaming on Kick as well as YouTube.
I'm not gonna lie. I think with everything,
He's got text to speech turned on, so anytime anybody gives a little.
house?
This is full of balls. Sorry.
Did we get the call for the police on their way?
Y'all better stay close to the door. They're telling them to leave. Finally. Here, get them.
It was them over there.
Finally protecting and serving.
Yeah, now everybody's gone. That's the bad part. Oh, what happened to the
Yeah, coincidentally, the air horn disappeared.
I saw a donation over here on JDon's page, and I thought it was on mine. I was looking for it to highlight. It was that one right there. It had me all confused. Wouldn't that be the thing? Would that like
you guys not making like noise and stuff?
we're
like
sitting
that.
here watching, and then all of a sudden,
No, I really appreciate that.
Judge
Are they,
Dad
like,
comes pulling up. Like, what did I tell you about coming back to this house?
No, they're talking to a guy. Yeah.
Imagine living in this neighborhood, y'all.
Here, we can take a quick picture.
Imagine living in this neighborhood. It's turned into a circus.
Like,
This has turned into a circus.
Anybody got a pen?
What is with the guitar? Why is... Dude, why you got a guitar? Dude, why are you getting him to sign your guitar?
Let's get a stream pic.
He's not a musical streamer. What?
Man, bro. Nice meeting you, bro. Y'all be safe getting home, all right?
I mean, it's cool.
Are you
I mean, it's cool he's doing it.
Yeah.
I don't know why. Look, the only thing I'm concerned with is Judge Dad just told him to stay away from this house.
All right.
They're throwing a party.
I appreciate y'all for being chill. Y'all be
Are we
safe going back
are
home.
we about ready to move on to our next case, our next set of cases? I think we have 2 more left. I can keep this running in the side, and we can check in with it at the end if you want to. What do you guys think? I'll keep an eye on it for breaking news coverage, and if anything happens, I'll break right in with it. How does that sound? This has been your live Lone Wolf Usul update of crazy happenings From the JDon live web stream,
Who was blowing
the
your
night
phone?
after Judge Dad told him to stay out of that
Like,
house,
rude.
and he just went on back. I think this will conclude our live presentation for the time being.
Sure,
Yeah.
bro. You got the bell bonds, bro? Bro, real one. I got you.
Appreciate it, bro.
We'll just turn that on down. Yeah. And back to our program. Still already in progress.
I'll agree. On the record, in the matter of the state of Michigan versus Mackay Edmonds 26-011, 144, council appearance.
Ross Marchmina for the people. This is Public Defender Joseph Hardy on behalf of Mr. Mackay Edmonds, who was standing here to my right.
Okay, Mackay Edmonds. This matter is scheduled today for a pretrial and then a bond show cause. And the reason why it sets for a bond show cause is because I had to remand you because I arraigned you. I gave you a curfew. Said you're not to be outside between the hours of 6 p.m. and 7 a.m. Unless you provided me evidence that you have a job. Have you provided me evidence that you have a job? Okay, well, I received multiple violations from your GPS tether. 21 pages of violations. That you were outside your home in violation of court order after 6 p.m. You didn't even, according to one day, you didn't even leave the house until 6 p.m. So you have the right to have a contested hearing on the violation. You have the right to have your attorney represent you on these violations. If you're found to be guilty of the violations, when you violate the court order for your bond, it's contempt of court. Each violation is a maximum penalty of 93 days in jail. Do you understand that? Okay, so I have here one violation alleges that on June 6th, 2026, let's see, you violated the 6 p.m. to 7 a.m. curfew. It says at 7:02 p.m. the defendant was at 534 Birch Road, East Lansing for 8823. He left the address, made several stops in the East Lansing area. He returned home at 1:24 in the morning at June 7th and stayed there for the remainder of the curfew. I then received another alert, June 8, 2026. It says the defendant violated the 6 p.m. to 7 a.m. curfew. At 6 p.m., the defendant was at 720 West Mount Hope Boulevard in Lansing, Michigan. He left that address and made several stops in Lansing. Mr. Evans returned to his home at 11:01 p.m. on June 8th and stayed there for the remainder of his curfew. Those several stops are what accumulated to 21 pages of data. How does your client want to proceed?
Apologies, Your Honor. I had spoken with him, as my understanding that these violations occurred because he was at his job. He built decks and various locations.
Do you want me to believe he's building decks at midnight? I didn't tell him he would 24-hour home arrest. I said that he could be outside prior to 6 p.m. So that means if he builds decks, what time was he supposed to build them? You're not going to anybody's home building a deck in the dark at 6 p.m. And he's lying. I have a GPS tether that tells me every address that he stopped at, minute by minute. You can't build a deck at 720 West Home between the hours of 6 o'clock p.m. and 6:04, and then now you're at 1. Put your hand down. 1027 Brahman Street for a couple of minutes, and then you're at 885 to 845 West Malcolm X Boulevard. Then you're at 349301 West Malcolm X Boulevard. Then you're at 501 South Capitol. Then you're at Townsend Street. Then you're at an address on South St. Joseph. Then you're on MLK. Then you're at an address on Lahoma. Then you're at an address on Westmoreland. And that you're doing this between the hours of 6 p.m. and 11 p.m. He's not building decks. Did you provide me evidence that you build decks?
But Your Honor, that night I was doing that.
Did I give you permission to leave the house for anything that was not your employment? Did you provide me evidence that you were employed?
I was also confused.
You were confused.
I was confused about the bond because when I went to court with Judge Stokes, when she reinstated it, I never got no paperwork. None of my lawyers ever told me which bond I was owed for either you or her. So when I got out of ICJ, when I got out June 6th, I asked them about the tether, and one of the questions was, what was my curfew? And they told me everything was the same. They told me my curfew was still 10, and I called pretrial services, and she told me she was gonna get that in line.
Get what in line?
See what my curfew was, because I told her I was confused about it.
So you knew you had a curfew?
Yeah, I thought it was still 10.
Where did you think it was 10 for?
From Judge Stokes' bond.
What is my name?
Yes,
This is the bond This is the bond form that you received when you were released. It says on there, not to be outside between 6 p.m. and 7 a.m. It says bond set by Judge Simmons. There's no confusion there. You spoke to me. I arranged you personally. The magistrate didn't arraign you and tell you what my bond is. I spoke to you directly. And I told you, you are not to be outside between these hours unless you provide me evidence of a job. I also told you you're not to use rideshare services. So I know you weren't outdoor dashing because I told you you're not allowed to, because the element of the mere crime alleges that you assaulted someone through an Uber. You weren't confused. You were doing what you wanted to do. Who is the person in the back that keeps raising their hand?
I'm sorry. That's my mother.
That's your mother? Ma'am, what's your name?
Allison Cotton.
Addison?
Allison.
Last name?
Cotton.
Cotton, what is it that you want to share?
I can be the witness that he was actually DoorDashing. I was unaware of the stipulations that was put on him because of the incident that happened, that he couldn't DoorDash because it was like, I was thinking it was like Uber or Lyft or something like that he couldn't come by DoorDashing. And also
You can come DoorDashing.
Like he could come DoorDashing with me, like DoorDashing.
You were DoorDashing.
We were DoorDashing.
No, not we. Who has a job with DoorDash?
I do.
He doesn't have a job with DoorDash. He's not allowed to leave the house during that time unless he provides me proof of a job, which is what I told him. So it doesn't matter that you didn't understand. You're not the one under court order. He is. And he is in an adult court. So he has to, it's not my problem that he has two different cases going and he can't keep it, me and Judge Stokes' order separate. That's not for me to figure out for him. And it's not for your attorneys either. That's really for you. Are you representing him in the matter before Judge Stokes?
No.
Yeah, so why would he be telling you about what's going on with Judge Stokes? He doesn't represent you on that matter.
My lawyer for Judge Stokes. I thought when I got the bond rearranged for Judge Stokes, I thought I was out on bond for Judge Stokes. My lawyer I never received no paper. I would have read the papers and I would have saw that I was out on bond from 6 to 7. I called pretrial services too, and I told her I was confused about it, and she said she was gonna look into it and let me know. She told me to call her back next Monday.
That's because you called pretrial services about a felony. That's what you call pretrial services for. Pretrial services is at the 30th Circuit Court.
I called her to check.
You didn't call her about file number 26-01448 because she would have told you we don't have that file. When you have multiple cases going, you have a question, you call about a case number because you have more than one case pending. She's thinking you're calling about the case they have over there. You mentioned Judge Stokes, so she's going to follow up on Judge Stokes' case for you. She's not looking into this case for you. You wouldn't call her for that anyways. You would call this court. You called circuit court to ask them about the bond over there. If you got questions about this court, you got to call this court. Your bond, I am going to reiterate, is set with a GPS tether. You have a curfew that you are not to be outside between the hours of 6 p.m. and 7 a.m. for any reason, unless you provide me evidence that you have a job, not that your mom has a job, or unless you have a medical emergency and you need to go to the hospital. Do you understand that? And that's because between the hours of 6 p.m. and 7 a.m., you're likely to find yourself in some trouble. I can appreciate that you were with your mother while she was out doing something late at night to earn money. But right now, you're not to be outside at all while this matter is resolved, because the allegations against you are not good. And you don't need you don't need any more. If they're lying, you don't want anybody else to lie on you. Correct? You also don't want any violations, because if you got violations, I have to send somebody to your house to arrest you. Because I don't know what's going on. I don't know why I'm getting all these alerts. I was on vacation. I'm getting notified that you're violating your bond. You think your mom wants to be in here? Is this your sister? You think they want to be in here seeing you like this? What is this that you build decks? Why didn't you tell them that? You weren't out building decks at night.
One night I was, but the other nights I wasn't sure.
One night so on the first violation, you're saying you were out building decks? The fourth, I believe. June 6th.
No.
You want me to be that you were out building decks? Because I have the addresses that you were.
It was my brother's graduation.
Your brother's graduation? From yeah, it says you were at MSU. I didn't know exactly where you were, but graduation don't happen until 1 a.m.
I stayed tonight.
Excuse me?
I stayed half the night.
Why? You trying to celebrate? Is this your son that graduated? You were trying to celebrate with your brother, but who said that you could be outside celebrating? You see what I'm saying? This is a reckless disregard for my order. And literally, if you had your attorney say his brother's graduating, can he go to the graduation? I would have amended your bond so that you can go to the graduation, not for you to stay out all night. Because who's he graduating from?
School.
What level of school? College, high school?
High school.
He's graduating from high school, and he has his own apartment or something. Oh, you stayed with him? You said though. On Forest Road. I'm sorry? Yeah, I think you were drinking in violation of your bond. What in the world would you be in the hotel in the middle of the night for?
I would think.
They were having a party. They were partying in a hotel.
Your Honor, with all of these allegations, I believe that your statements here today, I think that they are will serve as a wake-up call to him. I do think it'll be a wake-up call, and I do think that he understands after spending some time in lockup, just the gravity of what it would be to violate a court order. Only request would be today for him to have another chance to abide by your order. He has informed me that he does have a job, and he'd be willing to provide proof of that, and told me that his manager has set his hours from 8 to 8:30. So
Where?
Yeah, Frank Construction.
Frank Construction? Frank's Construction?
FRENC.
Oh, France Construction.
That we would just ask that he be allowed when he is going directly to and from work to be allowed to do so after 6 p.m. once he's able to provide a perfect schedule from his manager. I understand that 6 p.m. could be considered late, but the sun doesn't set till around 9.
I don't care what time the sun sets.
No,
It has nothing to do with sunsetting.
Yeah, no, I understand. I just, I just wanted to, make it clear that this is a job per his representations that, he does have, that he doesn't want to risk any more than he already has by missing work due to being incarcerated. So we would just ask that one, that he'd be allowed another chance out on bond with his tether, and for his bond to be modified to allow for him to keep this job.
When did you start this job? Almost a month ago?
It was like at the beginning when I caught the case with Joe Stokes.
I saw you. You told me you were unemployed. I asked you, what are you doing? You said unemployed. I wrote it down.
I said employed.
No, you said unemployed. That's what you said. No, I didn't ask you were you employed, and you said employed. I said, where do you work? That's what I asked you. You said you said you don't have a job. You didn't tell me that you worked in construction. What's your boss's name? Bill what? France.
FREN. It's like DT.
FRENT.
NDT.
Okay, what's his phone number?
He's a family friend. He did just start working with him recently. But he did just start working.
Where's your pay stubs?
He hadn't really been able to get a lot of days out of the job before.
On this 4 weeks or I'm being incarcerated from.
Yeah, but you told me you've been working there before you got the case with Judge Stokes. Huh? I can't hear you. Where's your pay stub? Okay. How much you make an hour? Okay. And what kind of work are you doing? You say you're breaking down?
Breaking down decks and building.
Breaking down decks and rebuilding decks. Okay. Where?
It's in various places. It can be. We go to houses.
Okay. You said it's a family friend, ma'am?
Yes. I have his phone number. It's 517-930-3300.
You need to provide evidence that you're employed with this borough grant. I need evidence by way of a check stub that you've been paid. Okay? Okay. I'm not doing a family friend. I got a job. You gotta show me proof that you got a job. You're not building decks until 8:30 p.m. either. Because you are out on bond. And you need to be home by 7 o'clock. Okay? So if you're working and I didn't give you any restrictions prior to, 7 a.m., it's fine, but you're gonna be home at 7 o'clock. Do you understand that? Because you're too young to have a felony and a serious misdemeanor pending. And on the path that you're on, you're gonna either be in prison or dead if you don't make a change. Do you understand that? Why are you looking at me like that?
I'm just taking it.
Oh, okay. Just making sure you understand. Okay. So, pre-trial, how are we handling this matter?
At this point, we would like to set for a final pretrial, Your Honor, just to make sure that the lay witness, the alleged victim.
There's been no offer at this time.
No, Your Honor. The people agree with the defense's request for a final pretrial and will convey an offer following victim consult.
July 21st at 8 a.m. for the final pretrial. July 21st, 8 a.m. in person at the court.
And then September 8th for the jury trial.
September 8th is the date scheduled for your jury trial. I say scheduled because there's others scheduled for that same date. So, and they probably have older case numbers than yours. So that means that you may not have the priority case that day, okay? But you still need to appear on both days, 8 a.m. in person at the court. I'll reinstate your bond at this time with the condition that you are to provide me evidence that you are employed with this bill print, building decks, by bringing a copy of your pay stub, okay? Once you would provide me evidence of that, then your bond will be amended to allow you to work outside of the home until I'll give you till 7:30 p.m. You understand? Okay. If you have other family things, you have to come and request permission to go to the celebration if it's outside of your home after a certain time. You can't just decide that you're going to make your own rules. You're under court order right now. Do you understand that? Okay. Now, do you have any questions about your bond conditions? Any confusion about your bond conditions? Are you sure? What's your home address? What's your phone number? Okay, no contact order will continue and until this matter is resolved. I think my understanding is that you've been suspended from Uber, but no ride share for you. Do you understand that? You're all set.
Thank you, Your Honor.
Thank you. Get you a copy of your dismissal. You're all set. Thank you.
Thank you, Your Honor.
No problem. State of Michigan versus Javon Terry Smith, 25-02764.
Ross Martin, Assistant Public Defender Joseph Hart against Captain Mr. Terry Smith, was standing here to my right.
This is scheduled today for a jury trial. This is for stalking of domestic relation and domestic violence. And he's representing himself.
No, he was representing himself through the final pretrial phase, but he reapplied with our office and I had since been appointed.
Oh, okay. I'm trying to see if I have his appearance for me. I don't think we do. Okay. So the offer that he originally had was to plead guilty to count 2 under 769.4A. Is that still the offer?
Yes, Your Honor.
Okay.
And additionally, there were additional allegations that I don't believe were filed, as far as allegations of violation of the PA 53 as part of this deal, upon conversations with Mr. Dan Smith, there was also an agreement that the prosecution would not move forward and recommend dismissal due to 3 violations as well, Your Honor.
I don't know if a violation has been officially filed as of now, but based on my conversations with Mr. Smith, this is correct. There are allegations of K53 violations that, as part of the agreement,
Where do these allegations stem from?
They stemmed from an allegation.
No, how did the prosecution's office find out about it?
that I don't know. Perhaps I don't know if it's jail call related. I think it might be jail calls.
No, so the allegation, as I understood it, was that the alleged victim had sent a video of an Instagram post that from a social media post that had alleged to show that Mr. Terry Smith was filming her while in no contact with her.
I'm looking at the plan. That's correct. It sounds like the people were given a video by the alleged in this matter that has been turned over to the defense. I don't know that a violation of court was ever filed.
Yeah, because the court's not aware and it's a bond violation. I'm not taking a plea. You want me to take a plea? And he has evidence of a possible bond violation and allegedly he picked up a new CCW charge. And then give him probation with 769.4A. It's already been given a deal. If I haven't even been told about the bond violation. So no, I'm gonna set this for a hearing on the bond violation. If you want me to put you on probation, you better hope that you were not violating my bond. I'm not babysitting adults anymore. They don't pay me to babysit adults. You're gonna be in control of your own behavior. And if the court tells you not to have contact directly or indirectly, not to engage in harassing, threatening conduct with the victim, there's no reason why I'm here on the day of your trial with allegations of a violation of that. There's no reason for it. You're the same person who came and filed this motion to try to get the case dismissed on basis that the court found to be frivolous basis because there was no police report called before that. It's not a basis to dismiss allegations that there was some stalking. And now I get allegations that there was more stalking. So I need to see the evidence. So we'll set it for a bond violation hearing and we will set this for a plea date. I'm going to advise you, you have the right to have a hearing on the bond violation that's been alleged. I see there's been an email that was sent from Mr. Smith back on June 9th. I think I was out of the office, but that is not a formal notification to me of a violation. So we will have that properly issued. I'm going to arraign you today. You have the right to have a contested hearing on the bond violation. A bond violation is a contempt of court order violation. And so if you're found to be in contempt, you're facing up to 93 days in jail in violation. Do you understand that? You have the right to have your attorney represent you at the time of any violation. We'll hold your plea offer open until that date and time because I may not be willing to grant him probation under 769.4A if he doesn't follow court orders. I don't want to waste my time or his. So you'll have more time to consider whether or not that's going to be an offer and whether or not you want to plead guilty without that offer if we find out that you have in fact violated your bond conditions. Do you understand that? Okay. The allegation of the conditions of recording, you said? Recording her?
Yeah, it sounds like he was filming her.
filming her house, allegedly.
Allegedly, it sounds like there was some sort of a phone video that he posted on social media, something like that.
Was it a new video or allegation that he posted the video?
My understanding is that it was a new video that was taken made while he was on podcast. That's my understanding.
Yeah, from the view of the video, the allegation was that he was in his car filming while she was walking.
Well, she was walking where? In her neighborhood?
The location was unclear.
It's unclear where the location is. And the victim's not here today.
She is here tonight.
Oh, okay. Could we find out where the location was? I'm trying to determine if I need to put him on a tether. Yeah. Got it. Did we get this criminal history? Did we get the other person's criminal history or
Yes,
just me? No, I'm direct. Oh, you direct. Yeah, direct.
It sounds like it was in the victim's neighborhood, very close to where she lives. So I do think that a GPS tether is appropriate. I will note for the record that this having occurred while the defendant was on bond could potentially support a charge of aggravated stalking.
Okay. I'm gonna have him remanded with a GPS tether. I'm gonna remind you of your bond conditions. You're not to have contact directly or indirectly with Micah Smith. Contact also includes posting about her on social media. Contacts includes you're not to be within 2,000 feet of wherever she is for whatever reason other than when you're in court. Do you understand that? Contact also includes that you're not to engage in any assaultive or threatening or harassing behavior towards her. And you're not to cause anyone else to do that on your behalf. Do you understand that? Do you have any questions about what might constitute a violation of your bond conditions at this time? Yes.
So what am I supposed to do about being harassed myself?
What do you mean being harassed?
I can't contact myself. Can I get some type of?
You can't contact who yourself?
She contacted me as well.
You mean on your phone?
Calling me from.
You don't.
Can I get?
How do you know she's calling you? How do you know it's her?
Same. I don't. It's just it's fake.
You believe that it's her? Are you answering the phone and then you're talking to her? Is what you're saying, or
no? It's just,
or you're answering the phone and you find out it's her, or is you saying that she is just you just getting these calls from fake numbers? You assume they're her.
Yeah.
Okay. Well, then you can't determine. We don't know who that is. We can't determine who it is just because you got a fake call. It could be her, could not be her. It sounds like you're not answering those fake numbers, and that's in your best interest to not answer a number that you don't know. If somebody calls you in violation, that's different. If you maintain the phone call, that's when it's on you. If you get a call from an unknown number and you answer it and you find out it's her and then you continue to talk to her, now you're in violation. You can't control her behavior, you can only control yours. You understand that? So if that were to happen and you were to answer, and you find out that it was her, you have to hang up. Then you should probably report that to the police immediately and to your attorney. That would go to your defense. Maybe she's talking you and not the other way around. I don't know. You need to report those things though, if you are to determine. But we can't just assume because you had weird numbers calling your phone that could have been her. It could have been Mr. Hardy calling. I don't know. It could have been your attorney calling to say, "Hey, you got an offer." You're screening your calls. You don't know who it is calling.
He's notified me of these, what he believes to be attempted contacts, and I have advised that he believes he has made stock that a police report could be filed.
Agreed. You would have to notify the police that you believe that you're being stalked. I don't know that they're going to investigate just some random numbers. The police would be investigating all day for everybody. We all get random phone calls from numbers we don't know. It just happens all the time. But if you are able to determine that, in fact, it is a Miss Smith, that needs to be reported, okay? Do you have any other questions about what might constitute a bond violation for you?
I believe my mother lives within a reasonable distance from my.
Who determined reasonable? Who determines that? You or me? Okay. Where in distance does your mother live from her?
Like 2 blocks north.
If he's been going to his mother's house, sounds like he just admitted to violating the bond.
He did not admit
going within 2,000 feet of where she
He
lives.
didn't admit to going to his mom's house. He just says he believes his mother
Okay.
lives
Right.
within.
That's something that can be determined from Google.
Yeah, maybe his mom's been visiting him, and he said, "Hey, 4th of July is coming up. I want to go to the cookout at my mom's house." I don't know. That's not what he admitted to. He carefully crafted his statement to say, "I believe my mother lives within a reasonable distance." I need Mr. Hardy to find out exactly the address of your mother's house to provide that to the prosecutor, so we don't have to put it on the record. And then if I need to make the exclusion zone within 500 feet, I'll do that to shorten the distance, to allow you to go to your mother's house. Not trying to prohibit you from going to your mother's house, I'm trying to prohibit any allegation that you are violating the order of stalking. That's all I'm trying to do. So you can tell Mr. Hardy what the address is. And then Mr. Marchinita will determine how close in proximity to the victim is. I don't know where the victim is, so telling me won't really help. And then I can craft your exclusion zone based on that, okay? You can do that.
Court, brother counsel has the Google Maps pulled up. We believe that it is outside of the 3,000.
2,000 feet.
2,000 feet.
So you're fine. You may have to configure how you drive to get to your mother's house so that you don't go within the 2,000 feet round. They'll give you an exclusion map that you requested. If you go within that, they will notify you. They'll call you. You don't want to not answer that. So you may not recognize the number. You want to answer because they want to see if you're violating your bond. If you answer and tell them I was driving through, they'll notify me. I don't violate people because they accidentally drove through the zone. I can see how quickly you entered and exited the zone when they send me the report. If I found out that you just drove through really quickly, that's one thing. But if it's a habitual thing, that's another thing. You understand that? Okay, so we'll keep it within the 2,000 feet exclusion zone at this time. And then, I'm assuming is the address that you gave, your mother's address, the address that you gave at the time of your arraignment on Fairview? Is that yes? Yeah. Oh, okay. So we'll keep that within the 2,000 feet. That's where you're living now, not your mother's house, correct?
Wait, where?
You said that you were living on North Fairview.
No, that's the address on my ID and living with my sister. That's the record.
Excuse me?
68.
When you were arraigned, the magistrate asked you what your address was and writes it down. You didn't tell us you were living someplace else. What is your address? Okay. Yeah. He gave, that's not the address he gave, that's not the address on his paper. It's in the system. Okay. Are you living on North Fairview or no?
Yeah.
Okay. Is that where your mail's gonna go to? Okay. So what is the middle line? Which address are you living at?
There.
It's not what you just said 2 seconds ago.
That's where I was staying.
You were staying there?
Staying in the area, yes or no?
You were staying at middle line with your sister, but you no longer stay there? Okay, because if you think I don't follow stories, I follow them pretty well. First, you said it was your mother's address on Fairview. Then you just told me I'm not staying there, I'm staying at my sister's house.
Staying at my sister's house on Fairview. Up until this day, up until just like a week ago, I was staying on Meadow Lawn. And I thought it was on, because I just got arraigned on the CCW, and that's the address that I gave him.
Okay, but this is not a CCW case.
So that's why I thought
No, you were arraigned on this case in February. You gave a North Fairview address.
That's where I was staying at in February.
Okay, and now it's where you're staying again? Okay. You should have been advised, and I'll advise you now, it's your responsibility to make sure the court knows in writing when you change your address, okay? Because we can't have a situation where we, A, don't know where you live, but B, we could change your court date. We got to mail it to you. You may not get it because you're not living there. So you have to let us know when you change your address, okay? So we'll keep the Fairview address now. That will be the address for your GPS tether as well as your home address, correct? Okay. If you can't speak and chew gum at the same time, you shouldn't be chewing gum at court. Thank you. We'll get you a notice to appear for your next court date, which will be when? July 7th. Okay. July 7th at 10 a.m. in person at the court. You and the victim must appear. Any additional matters for the record?
Nothing from the people.
No, Your Honor.
It's all set.
Yeah, so
You're going to get remanded and you put that in.
Well, let's check in with JD on. I got no clue what's going on. He's talking to somebody. Seems like it might be important.
You know, like those bikers that like protect kids that get bullied.
I don't know what's going on. The police showed up earlier and they talked to a completely different person that was not him. And then they left. And now he's back in the house sitting and streaming from a desk. That's what's going on there. And I'm what's going on here. I got no clue. I do know that I need to fix my screen. Because I can't. Oh no, that's not what I wanted to do. Need to. Yeah, there we go. We're getting there. We're getting there, ladies and gentlemen. I've almost. Oh, yeah, almost. Yeah, yep. We're set up for the end screen scroll. And ladies and gentlemen, I am your Lone Wolf Usul. Thank you so much for hanging out with me tonight. If you're interested in more of that JD stuff, you can go on over to JD's webpage. Do let him know that Lone Wolf Usul sent you over there so you can keep up with whatever's happening. Ask him if Judge McNally didn't expect him to stay away from the house. I don't know. Don't bug him too much though. He's working. You know how those things go. In the meantime, It's a good song. In the meantime, I'll be saying thank you to all these people, all these awesome people right here, especially Lanny King, Fat Boy is back, and Miss Natasha Kitty. Thank you so much, very much. Thank you very much for your contributions to the stream tonight. It's been an interesting one. Oh my God, it's been an interesting one. I mean, we started things off with Judge DiSanto, went through all of her stuff with all that. That's just, people cannot stop talking. You know, I'm one of them. And remember, when you're in court is not the time to be rattling off. The judge does not want to hear you talk. The judge wants to hear your lawyer talk. He wants to hear a succinct argument. He wants it over with as quickly as possible, and he wants to be able to give a decision. And that has nothing to do with hearing your rationality about your crazy reasons for why you did the stupid things you did. I say all that with peace and love, and mostly back at myself. I am looking at myself in the camera, saying, looking the dog in the eyes. Looking the dog in the eyes. Thank you for your support, ladies and gentlemen. We do this every single night of the week. Tomorrow is not going to be any exception to that. It is going to be a weird Wednesday. I'm sure of it. I don't know what's happening, but I know something is happening. So come on by and hang out with me, and we'll see what happened together. I'll get as much as I can from the court cases, and we'll have something to watch. It's always interesting, and it's always wonderful when you're out. For now, I'm your lone Wafusel, and I am out. I feel like I'm out of breath. Should I turn JD on back on? That's not JD on. That's JD on. Y'all got to see a little bit of the background stuff. Let's hear what they're saying.
Back in the bathroom. How you like your new door? When he moves out, I'll have a professional come and fix it up.
Oh, he's talking to the
Wait, what
squatter.
the hell? When did this happen?
A while ago. I think Joe did that. This.
Why would he do that?
I don't know.
Be careful walking down.
That was Bella.
Well, yeah, that's what we did. We're just waiting for him to come back and see it. But I don't know what happens.
Here, come with me. They drove by twice?
Yeah, not like straight down this way, but like towards the street.
I think they're just trying to make sure there's no fans out here. It's 11, so he could low-key walk by like in any moment. Here,
So keep in mind,
hop on the,
what's happening here is
that is kind of chilly.
JDon is kind of working with the landowner who's got a squatter.
Joe in the chat.
And he has technically rented the house from the landowner. And they are working together to try and force the squatter out of the home. Now, what we saw earlier tonight on the court cases we actually saw JDon in court with Judge McNally. And Judge McNally told him he needed to stay away from that house, and he has a stay away order from the squatter that actually is staying in the house also. And what we're watching now is the evidence that's going to be used in the upcoming contempt hearing that we might see in front of Judge Dad when he finds out this guy just did not listen to anything he was told to do.
That's me and y'all boys, man.
Now, that could be a stretch. It may not even happen. May not be any problems at all. Maybe the police are cool with it. Maybe the neighbors are cool with it. Maybe they've been down the street and talked to the neighbors and said, hey, This is what's going on. They have their own lawyer. He's got money. He's got means. He's got 5 million subscribers. He's got 11,000 people watching him across 2 platforms. 9,000 of those are currently on YouTube.
Jimmy Butler should have stayed
Jidion.
with the Heat. Boy, Giannis with the Heat now. You don't watch sports, do you?
I'm more of a Barry Sanders kind of guy.
Barry Sanders? Detroit legend.
Jidion
I'm more of
Premium.
a Joe Luciano. No?
Joe LaCree.
I'm a more Joe LaCree guy.
Okay, I like him too. Where are we going?
I was just going to take the route.
I don't know if we'll actually
it's not?
see this.
What?
Hold on, I got a couple of questions here.
Oh.
Don't know if we'll
thought this
actually
was the way to
see
make
this
Dublin.
as evidence in Judge Dad's case.
Bro, I
We
don't
may
freaking
actually see him back in front of Judge Dad. I'm wondering if it'll be before the end of the week.
Hey, I just moved into the
Possibly
neighborhood.
not.
Well, at least you're getting to know your neighbors and stuff.
Rhonda says that she posted in his comments. And I assure you,
It's only a 13-minute
Eileen, somebody has probably already shown Judge Dad. Judge Dad may be watching live just like we are.
Coming after Comptism like this.
Things have a tendency of getting around.
But every time I sign a shirt, I would just see on, whatever I sign, I would just see Lil Cum.
Judge
Like-
McNally is going to be very disappointed. You are correct about that.
So he just did a little tism. Yeah, he just did a little tism. Oh my god, bro. It's the same guy with everyone.
Is it?
No, those were the kids that just got it signed. Oh. Or took a stream thing just now.
Judge Dad is very
Where you
YouTube
at, Steve?
famous as well. That is correct. And numbers
Damn,
do
I'm not
not
gonna lie, like I feel
determine
empowered, like
right or wrong.
this is the route a legend takes.
But technically, I think legally speaking, if he didn't have the stay away order in place, if that did not
Bro,
exist,
I don't know why, but his
then
name
he
is
would be in the right
Joe.
because he's legally renting the property from the property owner. So he is Jadion is actually the legal
He's
tenant.
like waiting everywhere.
But it's one of those nebulous situations right now, right? Where the squatter is actually refusing to leave the property. And this, because of the stay away order, it doesn't matter if Jadion legally has the right to stay at the property or not. We've seen this 100,000 times where the guy owns the house where the family lives. The wife gets a stay away order from the guy, and the guy has to stay at the Motel 6, even though he pays for the property that everybody's staying on. It doesn't matter. So Judge Dad said, no, you can't go back to the house. Stay away from that location. He actually didn't say, I'm going to give Jadion a little bit of credit here. He did not say stay away from that location.
But I don't know why.
He
but
said
like, I just
stay
feel
away
like a
from
bad
that
kid.
person.
Like, the whole day. Like, I can't explain it.
This is River. That would be
I'm not
Riverview.
gonna
This
lie,
is Woodhaven.
Most definitely like a once in a lifetime stream. This was actually.
Yeah, I don't think we're gonna see him.
No.
He does still have to listen to court orders.
Where are we going?
I think a lot of us, I mean, there's a lot of creators out there with millions of viewers that we've never heard of.
No.
There was a point in time where I'd never heard of Mr. Beast. I mean, I've heard of him now, of course. But
I don't even know
there
what
may
he
be
is,
people,
so
there may
I'm
be
just walking
a few
around.
of you out there who've never heard of Mr. Beast and don't know how famous he is.
No, I might walk by it.
Yeah. I thought I had that chat cut off. Oh, that's in the upper corner. No, I think that's coming from mostly Kick. That is
Yo,
an
Jid
excellent
and
point,
Speed,
Matt
love you
Girl.
guys. Also, Joe smells like a moldy triple cheese burrito, and his face looked like I didn't wipe my ass for a whole year.
Oh, hey, dude, I'm trying to end the stream here. Oh my
Sacramento.
God. The language.
You're funny, bro. You're funny.
Thank
That was
you.
a funny
Thank you. I
comment.
try. Anyway, I don't got
crap,
anything
there's a
else. If
cat.
y'all want to go watch this cat, you can go watch this cat. I don't think anything's going to happen too much, but it's kind of cool. It's kind of cool what's going on. We know what the story is. We saw the court case earlier tonight, and this is happening live. This is the follow up. This is going on right now. But for now, me being your lone wolf Usul,
I'm surprised no fans offered to house Joe.
I'm going to
Offered to house him.
I'm going to say thank you
To house him?
and good night.
Like
I need to call my mama.
legitimately.
This stream is done. Go what? Go
think
watch
so?
Ferris
Like,
Bueller's
genuine?
Day Off or this guy. Go watch this guy. Gideon, I hope it works out for you, dude.
Like that?
Don't upset Judge McNally. Judge Dad is one of our favorites, okay? Okay, Jadion? Don't upset Judge McNally. I know you don't really care, but hey, man. Hey, Judge McNally. Judge McNally cares. And I bet you money if Judge McNally found out what was going on,
They have to
he'd
smash
be
them.
kind of on your side. He really would. He really would.
A crazy concept.
Yeah.
To even think about.
As Judge Mogan would say,
She's got to be down bad if that's the case.
bye.
I'm not gonna lie, like she looks like Joe's type.